So a lot of people think it's okay if I pass away and I don't have a will. I only have my children and my spouse. And the reality is, in Florida, while the default would be for your spouse to inherit your assets, if you and your spouse both passed away in a common accident, leaving minor children, it's not as simple as those assets going straight to your minor children. In Florida, minor children at this point can only inherit under $15,000 outside of the court system. So that means if you have any life insurance or any bank accounts that are over $15,000 worth of assets, and those are ultimately going to go to one child or even two children, then your children would have to have a guardian appointed through the court system. That is going to be a process. And if you don't have your documents in place, naming who you want your guardian of your children to be, then the court is going to make that decision for your family. So you could have an issue with a relationship with your parent or your sibling. The court might not know about those issues when you've passed away and might default to naming that particular individual as the guardian for your children because they assume that that close familiar relationship would be best for the child. This is why it's so important for you to get your estate plan set up. Make sure it is very clear who the guardian of your actual child should be. And then you can also name a guardian to handle the money that your child would inherit. Because in some instances, the person who is responsible for taking care of the actual child may not be the same person who would be responsible enough to take care of the assets or the money that that child is to inherit. So if this is something that you guys are interested in getting set up, our office does help with setting up the estate plan for individuals who have minor children, and we are able to name a guardian of the minor child as well as a guardian of the minor child's assets. And in some circumstances, we even name temporary guardians when the permanent guardian may not live in the state that you live in, or they may live too far away. For example, if you lived in St. Petersburg and your permanent guardian lived up in the panhandle of Florida, they may not be able to travel from the panhandle down to St. Petersburg within time to take possession of the child. In that case, you may want to name a temporary guardian to take possession of the child until the permanent guardian can come down and take possession. So there are a lot of intricacies into this area of law. It's something that we do very often, and we are happy to help you and your family get those estate planning documents in place and walk you through those decisions to make sure that you are comfortable with who you are choosing as guardian of your child and how your child will inherit any assets that they may receive when they are a minor. So give us a call, 727-280-6837. Thanks.